afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who have joined us early, thank you for waiting patiently. While we wait for the session to begin, we would like to share a short video about our firm.
I founded the firm in September 1985 with a vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Friendly Loans, Protecting and Recovering Your Money and Interest. My name is Jeromy, and I'm a pupil in Chambers with Mohanacomar Associates, and I will be your moderator for today's session. Before we begin, allow me to briefly introduce our firm and the work that we do. Mohanacomar Associates is a mid-sized law firm founded in 1985 by Dato' Mao and Kwai. Our able team today consists of 31 lawyers and a support team of 35. Following his retirement from the Court of Appeal bench in 2015, Dato' Mao now serves as a consultant with the firm. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talks series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcast live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. Should you require specific legal advice in relation to your matter, please contact us for a complimentary legal consultation. Further details will be provided at the end of this talk. We have two speakers for today. Allow me to introduce our first speaker, Ms. Sonia Mohanacomar. Sonia is an associate in our dispute resolution department. She was admitted to the Malaysian Bar in 2022. Sonia graduated from the Multimedia University in 2020. Her areas of practice include general litigation, insurance accident claims, corporate and construction disputes, employment matters, criminal and family law, as well as probate and administration. Our second speaker is Mr. Amir Nizam. Amir is an associate in our dispute resolution department. He was admitted to the Malaysian Bar in 2025. Amir graduated from the University of East Anglia in 2020 and later completed his Masters of Law at University of Essex. His areas of practice include general litigation and land disputes. In today's talk, Ms. Sonia and Mr. Amir will be speaking on, number one, how lenders can properly document friendly loans, how lenders can protect and recover their principal and interest, how borrowers may resist claims based on illegality or excessive interest, and we'll also be running us through some case studies. We will then conclude with a Q&A session. I will now pass it on to Ms. Sonia as our first speaker.
Thank you, Jeromy. Good afternoon, everyone. I'll be starting our discussion by looking at a very common situation, friendly loans, and more importantly, when a friendly loan may legally cross the line into money lending. So, what are friendly loans? Friendly loans are typically a one-off transaction made between individuals who share an existing personal relationship, such as family members, friends, or business partners, in order to assist the borrower in times of hardship. Common characteristics would include no formal agreement, WhatsApp discussions only, no repayment date, interest verbally agreed, and repayment linked to trust. For example, lending money to a sibling, helping a friend pay rent, or advancing money to a business partner temporarily. So these arrangements are often informal and are based on trust rather than business. Importantly, friendly loans themselves are not illegal. In Malaysia, this area is governed by the Moneylenders Act 1951. The act targets unlicensed lenders, loan sharks, disguised commercial lending arrangements, exploitative lending practices. The courts look beyond labels like friendly loan, advance, profit sharing, or investment. The common question that's usually asked is, was this really a friendly loan or was it money lending? The Malaysian courts examine loan given with interest or profit, repeated demands for repayment, use of agreements, post-dated or security, structured repayment schedule, multiple borrowers or organized lending activity, advertising, solicitation of agents, financing as a business activity rather than a private arrangement. Intention versus legal characterization. Subjective intentions would be just helping a friend. This wasn't a business arrangement. My intention was only to provide temporary assistance. Legal characterization would be what actually happened? Was profit expected? Was interest charged? Were there multiple loans? Did the lender behave commercially? Was there a repayment schedule? Even if parties call it a friendly loan, the court may legally characterize this as unlicensed money lending, unenforceable transaction, or illegal lending activity. Now, we look at Section 10 of the Moneylenders Act 1951. The Act states that where in any proceedings against any person, it is alleged that such person is a moneylender, the proof of a single loan at interest made by such person shall raise a presumption that such person is carrying on the business of money lending until the contrary is proved. Basically, Section A of the Moneylenders Act provides for a rebuttable presumption that a single loan with interest shall be presumed to be money lending until proven otherwise. It creates a legal presumption that a person is carrying on the business of money lending if certain conduct exists. This is significant because the court considers surrounding conduct and commercial reality, not just the party's statements. Examples: a 50,000 advance with a 10% monthly interest, or the lender repeatedly finances different persons, or the borrower signs repayment schedule and a penalty clause, or friendly advance, but the lender keeps profit margin and security documents. Instances where it is less likely to trigger a Section 10 would be one-off family assistance, genuine commercial investment or joint venture, temporary advance between business partners without lending intent, interest-free emergency loans. So, the core idea of the presumption. The law essentially says, if it walks and behaves like a moneylender, the court may treat it as one. The effect of Section A. The burden shifts to the accused once the prosecution proves a loan, an interest, or profit. The accused must then rebut the presumption by showing he was not carrying on a money lending business. Why does Section 10(a) matter? Normally, the person alleging illegal money lending must prove it. However, under Section 10(a), the burden may shift to the lender to prove they are not a moneylender once certain facts are shown. This makes litigation much harder for informal lenders who charge interest or repeatedly lend money. Courts have emphasized that even a one-off loan with interest may be enough to invoke the statutory presumption under Section 10(a). Rebutting the presumption, the defense must show that the transaction was isolated or exceptional, no system or business of lending, primary purpose was not money lending, or the money advance was for other genuine purposes. Now we'll be looking into case laws on rebutting the presumption. In Cosmopolitan Avenue Sendirian Berhad versus Nadayu Properties Berhad, the presumption was rebutted. This was what was held. I found that the defendant has in fact rebutted the presumption placed on it under Section 10(a) of the Money Lending Act 1951. One, that there was a relationship between the plaintiff and the defendant, where the defendant, in a bid to have ingress to the PHB land and the PHB buildings, has requested for the modification of the elevated ramp number 6 to allow the construction of the connection road thereto. The supplemental agreement, the CAA3, and all the letters issued between parties collectively evidence this relationship. 2, that there is an absence of any evidence of a system and continuity in money lending transactions by the defendant, where from the evidence in this case, the only lending of money was to the plaintiff. 3, that there is also no evidence that the defendant was carrying on or advertised itself in any way as a business of money lending. And 4, that the profit chargeable for advances was not exorbitant. Next, we have Triple Z Trading and Suppliers and Others versus Applied Business Technology Sendirian Berhad. The federal court held in this case that an interest rate of 100% is an exorbitant rate, and unless the presumption that the lender is carrying on the business of money lending is rebutted, such a lender will be considered as carrying on a money lending business, which requires a license under the Money Lending Act 1951. In Sandhu Singh versus Seladurai, the court held that the appellant had failed to rebut the presumption. Some brief facts of the case. The appellant had lent to the respondent. The respondent issued a check for acknowledgement or security, which was dishonored. Appellant sued for recovery. Respondent claimed appellant was an unlicensed money lender. The presumption here, proof of money lent with expected interest, raised the statutory presumption that the appellant was a money lender. After one transaction is proven, the burden shifts to the lender to prove they were not carrying on a money lending business. Now, why did the appellant fail? The court relied on evidence that the appellant previously acted as obtained a money lender's license, described himself as a money lender, interest on the loan. Lastly, we have Wong Tian Choi and another versus Goodnight Sendirian Berhad and another. The plaintiff successfully rebutted the presumption in this case. The court found that the plaintiffs were genuine businessmen in the furniture industry, not carrying on a money lending business, not advertising or holding themselves out as money lenders. The court also noted in this case that loans arose from long-standing business relationships, money came from personal bank accounts, and the defendant produced no evidence of any lending business. With that, I'll conclude my part of this session. Thank you everyone for your attention, and I will now pass the floor to my colleague, Amir.
Thank you, Sonia. Hello, everyone, and good afternoon. So for my section, I'll be highlighting specifically on the aspect of interest rate, particularly where it may be considered too high. In other words, exorbitant. So a bit of a recap, as explained by Sonia already, under Section 10(o) of the Money Lenders Act 1951, where anyone lends money at an interest rate is presumed to be a money lender, as opposed to being merely a friendly loan. So let's look into how the interest rate might play into this. So a very good case, as Sonia has raised, was the case of Triple Z Trading at the federal court. So a bit of the brief background facts of this case is that here the lender had lent around 800,000 to the borrower. Very interestingly, it was labeled as an agreed profit as opposed to an interest rate. And the principal sum, as well as the quote-unquote agreed profit, was supposed to be repaid within a short period of time, around 30 days. Upon the borrower's default, of course, eventually the lender initiated legal proceedings and tried to claim both the principal sum of 800,000 as well as the supposed agreed profit of 100% on that principal sum. Let's look into the court's findings in a bit more detail here. So as you can see, the federal court looked past the labels used by the parties. So even though it was expressly labeled as an agreed profit, it is in essence and in effect an interest rate, and the court treated it as such. So in this case of an agreed profit of 100% interest rate. So the court held that the exorbitant interest rate triggered the presumption, the Section 10(a) of the Money Lenders Act, and therefore the lender in this case was presumed, in fact, to be a money lender. Eventually, the court definitively ruled that this transaction was an illegal money lending arrangement instead of being a genuine friendly loan. So, okay, what is the effect when this happens? After there is an exorbitant interest rate, the court has presumed you of being a moneylender under the Moneylenders Act, then the money lending arrangement is void, is no longer valid. So what usually happens when in these sorts of situations? One remedy that can be available is restitution under Section 66 of the Contracts Act. In essence, what this means is that whatever was given under this arrangement, which has since become void, has to be returned. So normally, for example, this 800,000 ringgit that was lent, therefore must be returned back to the lender from the borrower. However, in this case of triple Z trading, the court found that the exorbitant interest rate of being 100% agreed profit was an unlawful consideration. This essentially rendered the entire agreement void ab initio, meaning from the very beginning, from the very start, pursuant to Section 24 of the Contracts Act 1950. So where the contract is declared void ab initio due to such illegality, the court held that restitution is no longer available as a remedy, meaning the money that was lent, in this case, could not be returned anymore. So the court warned that if illegal lenders are guaranteed recovery of their principal sum, this would create some sort of a fertile breeding ground for unlicensed moneylenders. This might sound a bit harsh considering you've lent some money. It turns out the interest rate that you expected you'd get, you couldn't get anymore. You think you'd be able to at least claim the principal sum. However, the court has held in such cases where the exorbitant interest rate is so egregious, the party, as in the lender, can no longer claim back the principal sum anymore. And this is what we call the loss falls where it lies principle. And a very helpful and excerpt of the judgment is reproduced in paragraph 23 and 24 here, which shows that, again, as mentioned, it would create a fertile breeding ground for illegal moneylenders, aka alungs, because in the event the borrower does not repay, the principal loan amount guaranteed to be recoverable through the court process. The court, in fact, went on to say that it can be likened to allowing a robber to claim back their costs and expenses in a botched robbery attempt. So more than anything, the case of triple Z trading highlights just how important it is to consider the risk of having an interest rate in a supposed friendly loan arrangements. But it does raise the question, if triple Z trading says 100% within 30 days is exorbitant, is there a permissible rate of interest that can be used for friendly loan arrangements? So a useful case to look at here is the case of Menta Constructions in Yamahat. So the brief facts of this case is that the plaintiff, i.e. the lender, had advanced 1.2 million ringgit to the defendant to assist with financial costs of an ongoing construction project that they're involved with together. So the parties executed a loan agreement, and under this loan agreement, there was an administrative charge, so to speak, of 8.8% of. Later, subsequently, the defendant defaulted on the repayment and the plaintiff sued to recover the principal sum along with the administrative charge, which accrued at this point to nearly the entire principal sum. So what happened in Menta Construction is that, again, calling it administrative charge is merely a camouflage of what it is, which is an interest rate, and the court will recognize it as such. In this case, the High Court determined that the 8.8% was just interest rate because they looked into how there were no actual services rendered to justify such a charge. So what's interesting in this case is that the High Court refused to enforce the contractual 8.8% rate, but instead exercised their own discretion to award a SIM interest rate of 5% per annum on the principal sum. So what's useful to see from Menta Construction is, again, if we have that recurring theme of labeling things, labeling the interest rate under different names doesn't solve the problem. The court will identify it. Secondly, what is interesting from Menta Construction is that the court has discretion to strike down interest rates which the court considers exorbitant and move on from there to impose a more appropriate or a reasonable rate. So moving on to the next case to look at is the case of To Hong Chu against Pyo Chung Fa. So in this case, the plaintiff and the defendant were formerly husband and wife. The plaintiff provided several loans to the husband throughout several years, eventually, and they executed a formal friendly loan agreement acknowledging a debt of 1.52 million ringgit. And here the agreement stipulated, again, an administrative charge of 1.3% per month. Even though the rate was 1.3% per month, the court here held that it was not actually exorbitant, given the context of the facts. And the important context of the facts here is that the plaintiff successfully rebutted the presumption under Section 10OA of the Moneylenders Act by showing the existing domestic relationship, their history between the plaintiff and the defendant, and also that there was a lack of system and continuity in the wife's lending. So to go back to what Sonia had elaborated on the different ways to rebut the presumption under Section 10OA, this shows that the facts really do interact with one another. Given an interest rate, it might be with other relevant factors, in this case, due to the relationship between the parties, and also proving that there was no system or continuity. So ultimately, the court here decided that the defendant had to pay the principal and enforce the 1.3% monthly interest that was agreed upon. All right, so after looking at those few cases, what can we gather from previous court decisions? So the most important thing is that there is no one-size-fits-all number in terms of interest rate. Menta construction still stands as a very useful guide, suggesting 5% per annum is a reasonable rate to use in friendly loans and to ensure that it's not construed as a money lending arrangement. But at the same time, you have cases like To Hong Chu, where a 1.3% per month interest rate can be held to be valid, depending on, in this case, it was the closeness of the parties, but considering other relevant factors, it can also be used to justify or at least explain a higher interest rate compared to Menta Construction's 5% per annum. But in any event, Triple Z trading still stands as a good warning of what not to do, which is 100% interest rate within 30 days, which the federal court held very conclusively and very clearly to be exorbitant and a clear indicator of illegal money lending, and in such cases will lead to total loss of recovery. On top of that, to reiterate, what other key determining factors can we look at to say that a friendly loan is in fact legal? So purpose: was the loan for mutual assistance? Was it for commercial necessity, such as it was in Menta Construction? Or is it just for pure profiteering, which would be construed to be a money lending arrangement? Another thing is the label use. The court, time and time again, will ignore labels like agreed profit or administration charges and look at the actual essence and effect of additional charges, which are in essence interest rates. Another thing to consider is existing relationship between the parties. A loan to a spouse or a long-term business partner, or essentially any sort of existing relationship between people, can show that it is more likely to be a friendly loan between parties, as opposed to, for example, if a loan is given to a complete stranger, then it's assumed that the intention there is merely to profit and to make money, which is, of course, construed to be a money lending arrangement. All right, considering the presumption under Section 10OA of the Moneylenders Act, considering the grounds and the factors to look at how to rebut, as well as how the interest rate plays a very key and crucial role, what are the things that everyone should consider in terms of ensuring that their loans are in fact friendly loans, which can be enforced, as opposed to being construed and held to be money lending, which may lead to a total loss of recovery? So do's: how to protect yourself, get everything in writing. And this, of course, is applicable to any agreement, especially any money lending agreement. And in this case, it's especially useful to show purpose, because as you remember, showing the intention of the parties, establishing the relationship is useful and essential in potentially rebutting a presumption of money lending under Section 10OA. And a good thing about getting it in writing, of course, is setting a fixed and specific repayment date. Going back to the interest rate aspect, it would be advisable to avoid interest rates at all, if possible, considering the presumption now under Section 10OA, which does say that any interest rate will raise the presumption. But in light of cases, Menta Construction does suggest 5 per annum to be a more reasonable and acceptable rate. And lastly, do have clear evidence that the arrangement is not to make profit. If it is intended to make a profit, then it's no longer a friendly loan. The purpose has changed. So what are the helpful evidence that you may consider to have in hand? So things like the business or investment documents, which shows purpose, shows intention, which shows the terms of payment. It's important to be able to show the absence of multiple loans. If you remember, showing a lack of system or continuity in the lending is a ground to rebut the presumption. So if you can show that in actual fact that this was a one-off loan between parties, then it's more acceptable to be friendly loan. Next is any correspondence showing the context of this arrangement. Again, purpose, intention. And lastly, no advertisement or solicitation. Advertisement, of course, if you're going out into the world advertising, lending out money, that will be construed as you running a business trying to lend out money. A solicitation, if you go around suggesting or proposing to people that you want to lend them money, again, the purpose and intention that you have may be construed to be for money lending as opposed to you wanting to give merely a friendly. So what are important don'ts? Don't lend to strangers. There will be no relationship between the parties, which may suggest the purpose of the agreement to be making profit and therefore being money lending. Don't make a habit of lending out money. Making it a habit, showing that there are multiple loans, this establishes a sort of system, and therefore the presumption of money lending will be more difficult to rebut. And lastly, we see again and again, don't try to disguise any interests under different names, such as administration charges or agreed profit. Any additional charges to a principal sum, the court will look into it, and if it is in essence an interest rate, the court will treat it as an interest rate. And we can see from previous cases like triple S trading, where you have such a high and exorbitant interest rate, which the party tried to hide under a different name, the court's more likely to see it as a disguise. And yeah, in essence, that much covers the topic of today's talk, which is on the presumption of money lending under Section 1008, as well as covering the various grounds to rebut that presumption, where we highlighted the crux of money lending, which is the interest rate aspect. I now give the floor back to Jeromy, and we'll accept questions from the audience.
Thank you to Sonia and Amir for your valuable insights on today's topic. We will now take questions from the participants from the Q&A box. So for our first question, it is, what should I check before taking a friendly loan from someone? I think for this question, I will pass it on to Amir.
Thank you, Jeromy. So if I have it correctly, what should someone check before taking a friendly loan from another party? So again, you should check the terms of this friendly loan. So make sure that both parties agree on the amount of the loan, the date of repayment, and whether or not there's any interest. It's, of course, as usual, best to get these things written down clearly to avoid any misunderstandings, as well as to spell out very clearly the intention of parties and the expectations of this friendly loan. Yes, that's about it.
Thank you to Amir for your answer. And now for our second question. In the absence of a formal written agreement, what types of evidence are generally useful in proving the existence of a friendly loan? I will now pass this question to Sonia.
Thank you, Jeromy. In the absence of a formal written agreement, the types of evidence that are most useful in proving the existence of a friendly loan would be, for example, bank transfer records or transaction slips, messages or communication records like WhatsApp texts or Telegram texts or emails, whatnot. Witness testimony, partial repayments or interest payments, acknowledgement or debt, even informal. Thank you.
Thank you to Sonia for answering that question. And now we'll move on to another question, which says, how do friendly loans differ from bank loans in terms of risk and formality. I think for this question, I'll also pass it back to Sonia.
Thank you, Jeromy. How do friendly loans differ from bank loans in terms of risk and formality? Friendly loans are less formal, often without contracts or interest, but they carry higher personal risk because they rely purely on trust. So, compared to bank loans are more structured with legal agreements and stricter repayment rules. Thank you.
Great answer, Sonia. And we have also another question which states, what are the advantages and disadvantages of using friendly loans? I think for this question, maybe we'll pass it to Amir.
Sure. Thank you, Jeromy. What are the advantages and disadvantages? What are the pros and cons of using friendly loans? So friendly loans, they're more straightforward, they're faster, they're more flexible. They do, however, are based on trust without strict requirements like credit checks or paperwork. And subsequently, because of that, they can also carry a higher risk. That's something important to consider as a disadvantage. Friendly loans, of course, because they can be a bit more flexible, sometimes the repayment terms might be a bit unclear, or there may be a lack of any legal protection in instances or possibilities of default. And of course, friendly loan, if it's to a friend or to a family member or to anyone with long existing history, you do have the risk and potential of damaging that personal relationships if problems arise. So again, the pros and cons are definitely there in terms of it being more easy to have, a bit more casual, less bogged down with requirements, but those requirements are there for a reason, but that is the trade-off that you get in terms of friendly loans.
Thank you for your answer, Amir. And now we have another question from Wei Fong Wong. And the question is, just wonder, to what extent are electronic communications such as WhatsApp, emails, and online banking records admissible and decisive in establishing the existence and terms of a friendly loan? So for this question, I think I will pass it to Sonia.
Thank you, Jeromy. Electronic communications like WhatsApp chats, emails, online banking records, and whatnot are generally both admissible and quite persuasive in proving the existence and terms of a friendly loan, especially when there is no formal written agreement. However, the strength of it depends on the context and supporting evidence. Thank you.
Thank you, Sonia. And here we have a question which states, would you recommend the parties drafting a proper written document signed by both parties to show firmer documentary proof, or have the transaction be recorded in WhatsApp or email to show lack of money lending system? So I think for this question, I will pass it to Amir.
Sure, thank you, Jeromy. So as a general rule, having proper written documentation is encouraged to show the expected terms of payment, the amount, as well as the purpose and intention between parties that this is in fact a friendly loan. In terms of whether would it be better to be recorded in WhatsApp or email, this does raise the risk that we talked about, which is that it can be more difficult to enforce or to point out the exact terms of this loan agreement. In terms of whether it shows a lack of money lending system by using email and WhatsApp, to our knowledge, that is not necessarily a risk just by having proper written documentation. Also, in terms of system, what we have seen is that it looks into system and continuity, which shows multiple loans or a habit of giving out loans. So again, as a general rule, written documentation very much encouraged in terms of handing out or having a sort of loan arrangement.
Thank you very much, Amir, for your answer. Once again, thank you to Ms. Sonia and Mr. Amir for their insights into this talk. And just before we conclude, I have just a few announcements to make. First, please join us again for our upcoming talk, which is entitled Breaking Deadlock, Termination of Co-Proprietorship in Malaysia, and will take place on 10th June 2026 on a Wednesday. And secondly, please do fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. And thirdly, do follow or like our social media accounts, which is currently being showed on the slide. And lastly, if you would like to speak with our lawyers, we offer a complimentary consultation up to 30-minute over the telephone or over video conference. Please fill in the form from our website, and the link is also posted in the chat box. Thank you very much to everyone, and to our guests. Thank you for joining us. We hope you have found today's session to be informative and also useful. Thank you, everybody, and see you at our next talk.